This is a document presented to the Federation of Independent Forensic Research Council of Nigeria (FIFRCN) and is a case study or as in the study of the faculty of conscience. In a broader sense, equity. We are going to study the nature and scope of equity, which includes origins and history, the doctrines of equity, what is equity, differences between common law and equity, administration by different courts, incompleteness of equity, discretionary nature of equity, limited enforceability of equitable rights, nature of equitable interest, purchaser without notice. We will also look at the B part, maxims of equity, and we have at least here we have at least 11 maxims of equity. Equity will not suffer a wrong to be without a remedy. Equity follows the law. He who seeks equity must do equity. He who comes into equity must come with clean hands. Delay defeats equity. Equity looks to intent rather than the form. Equity acts in personam. Equity looks on that as done which ought to be done. Equity imputes an intention to fulfill an obligation. Where there is equity or equality, the law must prevail. Where the equities are equal, the first in time prevails. We will also look into the C part, which is the equitable remedies, which are being divided to 1 to 6, from 1 to 6. As one is auxiliary jurisdiction. Second, some kinds of equitable remedies: appointment of receiver, discovery of document, specific performance, injunctions to restrain breach of contract, and injunctions in other cases. Firstly, we're going to start with the nature and scope of equity, the origins and history. Note the two meanings of equity. One, original meaning natural justice or fair play, and modern technical meaning, which is the rules of law administered by the High Court of Chancery before the fusion of the courts by the Judicature Acts 1873 to 1875. Two, equity can also mean recourse to principles of justice to correct or supplement the law as applied to particular circumstances, e.g., the judge decided the case by equity because the statute did not fully address the issue. 3. Again, equity or natural equity is the system of law or body of principles originating in the English Court of Chancery and superseding the common and statute law, together called law in the narrower sense when the two, that is the common law and the statute law, conflict. E.g., in appealing to the equity of the court, she was appealing to the king's conscience. 4. Equity is that system of justice which was developed in and administered by the High Court of Chancery in England in the exercising of its extraordinary jurisdiction. This definition is rather suggestive than precise and invites inquiry rather than answers it. This must necessarily be so. 5. Equity in its technical and scientific legal sense means neither natural justice nor even all that portion of natural justice which is susceptible of being judicially enforced. It has, when employed in the language of English law, a precise and limited signification and is used to denote a system of justice which was administered in a particular court, the nature and extent of which system cannot be defined in a single sentence, but can be understood and explained upon which it acts. Lastly, number 6, in order to understand what equity is, it is necessary to understand what the English High Court of Chancery was and how it came to exercise what is known as its extraordinary ordinary jurisdiction. Every true definition of equity must therefore be, to a greater or lesser extent, a history. 7. In another technical sense, equity may be defined as a portion of natural justice which, although of a nature more suitable for judicial enforcement, was for historical reasons not enforced by the common laws, an omission which was supplied by the Court of Chancery. In short, the whole distinction between equity and law is not so much a matter of substance or principle as form and history. 8. The term equity is an illustration of Mr. Tolkien's proposition that some words have a legal meaning very unlike the ordinary one. In ordinary language, equity means natural justice, but the beginner must get that idea out of his head when dealing with the system that the lawyers call equity. Originally, indeed, this system was inspired by ideas of natural justice, and that is why it acquired its name. But nowadays, equity is no more and no less natural justice than the common law. And it is, in fact, nothing else than a particular branch of the law of England. Equity, therefore, is law. The student shall not or should not allow himself to be confused by the lawyer's habit of contrasting law and equity, for in this context, law is simply an abbreviation of the common law. Equity is law in the sense that it is part of the law of England. It is not law only in the sense that it is not part of the common law. On the other hand, equity is a right, interest, or remedy recognizable by a court of equity. Example, there was no formal contract formation, so they sued for breach in equity. We will also look into the doctrines of equity. 1. Equity simply means fairness, a system of natural justice that allows a fair judgment in a situation which is not primarily covered by the existing laws. 2. Equity is a set of rules of laws as administered by the Court of Chancery before the fusion of the courts by the Judicature Acts of 1873 and 1875. 3. Equity was primarily developed as a form of appeal on the decisions based on the common law to the king's conscience. It is also a case law developed by the Court of Chancery in England to mitigate the harshness of the common law system. For the common law in England is a system of laws which have been developed from various English customs and from the case laws based on the decisions made by the judges in the British Court of Law in earlier cases. Most of these common law verdicts and doctrines were without credibility and absolute justice to nature. Therefore, the English common law system then lacked equity and perfection, thereby creating a gross injustice in the English court of law. And it is mainly for this obvious reason that the Lord Chancellor of the Court of Chancery upheld and administered equity to granting a relief to an aggrieved party whose complaint of injustice arising from the administration of common law rules had been heard and upheld. In today's Nigeria, equity is clearly observed and done in the Court of Appeal. And any regulatory, criminal, or civil judgment in the absence of equitable resolution results in the failure or miscarriage of justice. What is equity? We are going to look into the definition of equity. Equity is, in civil law, the general admissibility of natural law or natural justice, the perfect observance of a set or body of philosophical system of legal and moral principles embodied in the principles of fairness, constituting of what is right and wrong, and purportedly derived from a universalized conception of human nature or divine justice, on which human behavior, such as the act of and the quest for impartiality, even-handed dealing, happiness, goodness, affection, or kindness, is certainly based, as well as the enforcement of such conscience, as a moral responsibility that one naturally owes a fellow, rather than from a perfect obligation, which as per se incurs a legislative or judicial action. Many ethical teachings and standards today are based on equity and natural law. The inalienable rights, such as the freedom of conscience incorporated in the UNDHR, reflect the influence of equity. 3. Natural law, as it is revived today, seeks to organize the ideal element in the law, to furnish a critique of the old received ideals and give a basis for formulating new ones, and to yield a reasoned canon of valued and a technique of applying it. Roscoe Pound calls natural law a philosophical jurisprudence, though one can sympathize with those who salvage the goodwill of the old name as an asset of the science of law. It is true that when the medieval writers spoke of natural law as being discoverable by reason, they meant that the best human reason could discover it, and not, of course, that the results to which any and every individual's reasoning led him was natural law. The foolish criticism of Jeremy Bentham states that a great multitude of people are continually talking of the law of nature, and then they go on giving you their sentiments about what is right and what is wrong. And these sentiments, you are to understand, are so many chapters and sections of the law of nature, merely showed a contempt for a great conception which Jeremy Bentham had not taken time to understand. Natural law is often an idealization of the opposite to that which prevails. That is to say that where inequality or privilege exists, natural law demands its abolition. 7. Equity in its popular sense is practically equivalent to natural justice, which is justice as defined in a moral as opposed to a legal sense. But it would be a mistake to suppose that equity as administered by the courts embraces a jurisdiction as wide and expansive as that which would result from carrying into operation all the principles of natural justice. There are many matters of natural justice wholly unprovided for, from the difficulty of framing any general rules to meet them, and from the doubtful wisdom of a policy of attempting to give a legal sensation to duties of imperfect obligations such as charity, gratitude and kindness. A wider or larger proportion of natural justice in its widest sense is thus not judicially enforced, but is left to the conscience of each individual. Although the judges have frequently asserted that a foreign judgment which contravenes the principles of natural justice cannot be enforced in England, it is extremely difficult to fix with precision the exact cases in which the contravention is sufficiently serious to justify a refusal of enforcement. Shadwell VC once said that whenever it is manifest that justice has been disregarded, the court is bound to treat the decision as a matter of no value and no substance. But this goes too far. The expression contrary to natural justice has, however, figured so prominently in judicial statements that it is essential to fix, if possible, its exact scope. The only statement that can be made with any approach to accuracy is that in the present context, The expression is confined to something glaringly defective in the procedural rules of the foreign law. In other words, what the courts are vigilant to watch is that the defendant has not been deprived of an opportunity to present his side of the case. Then, perfect obligation is to common law, imperfect obligation is to equity. Natural law is the embodiment of morality, while equity is the enforcement of morality as a natural obligation. Perfect obligation is a legal enforceable obligation that is recognized and sanctioned by positive law. Positive law is a system of law promulgated and implemented within a particular political community by political superiors, as distinct from moral law or law existing in an ideal community or in some non-political communities. Positive laws consist of enacted laws such as the codes, statutes, and regulations that are applied and enforced in the courts. This term is derived from the medieval use of positum, Latin meaning established, so that the phrase positive law literally means laws established by human authority, also termed made law or jus positivum. A judge is tethered to positive law but should not be shackled to it. Patrick Devlin, The Enforcement of Moral, page 94, 1968. We are moving on to the differences between common law and equity. A. Administration by different courts. Before the 1873 Judicature Act, this was the major difference between the common law and equity. Therefore, a person seeking both a legal remedy such as damages and an equitable remedy such as an injunction might have to bring separate actions in a common law court and in the court of chancery. The two cases might then be decided differently. Where this happened, the court of chancery would at one time issue a common injunction forbidding the winner of the common law case. Injunctions have ceased to exist since Common injunctions have ceased to exist since the Judicature Act of 1873. B part, incompleteness of equity. For a long time, both the common law and equity as systems of law were administered in different courts. However, by the Judicature Act of 1873 and 1875, both rules of law were fused and administered in the same court. This fusion notwithstanding, there still existed some basic distinction between the common law and equity. The common law was a complete system, while equity was merely a gloss consisting of isolated supplementary rules intended to fill in gaps in the common law. In other words, while it is possible to dispense the common law as a separate entity, the same is not true of equity, which at best only serves as a supplement to existing common law rules on the same subject. Also termed natural equity, it does not operate in isolation. Rather, it is the recourse, the fact of having to, or being able to, or being used as an explanation to principles of justice to correct or supplement the law as applied to particular circumstances. Hence, judges decide most cases by equity because some existing laws or the statute do not fully cover and address some issues. Equity is always based on the rules of common law which act directly on persons, actions and things. Its rule is essentially complementary. Part C. Discretionary nature of equity. At common law, the court is bound to grant a legal remedy to a plaintiff who can prove beyond reasonable doubt the infringement of his legal right. But the Court of Chancery always reserved to refuse an equitable remedy to a plaintiff who had himself acted inequitably or unfairly. This distinction still applies today. to the award of legal and equitable remedies. Most importantly, equity grants to the judges the moral right to use discretion in waiving legal flaws and technicalities of laws or rules that could have resulted in gross injustice. However, there is the established principle of law following a dispute between the Chief Justice and the Lord Chancellor on the power and exigent of application of equity rules. This controversy was finally resolved in the celebrated Earl of Oxford case, in which it was held that where there is a conflict between the rules of common law and those of equity, the rules of equity would prevail. The main rationale for this verdict by King James I was to ensure that justice was not only done to parties but should be seen to be done at all times. It suffices to state that in the case of Nigeria, when occasion so demanded that the courts should administer common laws and equity, such should be administered with the cognizance for prevailing local circumstance, verbal alterations and Nigerian legislation. Equity must be a foremost nature of every competent court of law. In other words, common law on stringency demands for who and whose action is right or wrong, while equity on competency strenuously looks out for what is right or wrong. And when the court fails to abide by the rules of equity so as to ascertain what is right or where it goes wrong morally before requesting for who is legally right or wrong, the court plunges into miscarriage of justice. Therefore, the rules of equity must be seen at the forefront of the rules of law in order to uphold absolute justice, and where the latter supersedes the former, equity must follow to create a judicious legal balance in conformity with natural law. In a nutshell, where law conflicts equity, then equity must prevail. Lastly, equity is the enforcement of moral conscience, known as imperfect obligations, while the common law is the enforcement of legal obligations, known as perfect obligations. We are going over to the limited enforceability of equitable rights. So we are going to look into the limited enforceability of equitable rights. Equity in legal law is the enforcement of moral obligations by the accused to the complainant. For example, thus if Lord Marshal borrows money from Miss Rosemary to support Miss Brown, equity will compel Lord Marshal to fulfill his voluntary promise on Miss Brown, even though it is unsupported by consideration. Equity here is Lord Marshal's moral duty by nature that motivates him to make a promise and keep to his promise. Promises are kind acts of nature that only our morality can compel them to be done. That is to say that those natural human tendencies that make man fail or keep to his promises are neither questionable nor legally enforceable. And it is of no offense to Miss Rosemary if Lord Marshal either used or failed to use the borrowed money for the benefits of Miss Brown as he had promised. And Miss Brown's right is a personal moral right against Lord Marshal only. Therefore, when Lord Marshal buys his clerk who has no notice of the trust or knows nothing about the earlier plans with the borrowed funds, a vehicle, rather than paying the hospital bill for Miss Brown, who was delivered of baby, Miss Brown cannot carry out any legal actions against the clerk. Though Miss Brown still has a personal moral, though the though Miss Brown still has a personal moral right of action in a civil court to sue Lord Marshal for negligence of duty and breach of trust only if Lord Marshal was morally responsible to support her hospital bill either as her husband or otherwise. Further, the essence of equity is the enforcement of moral obligations owed by the defendant to the plaintiff personally. Thus, where T acquires property from G by promising to use it for the benefit of B, equity will compel T to carry out his bargain. Even though it is unsupported by consideration, but B's right is a personal moral right against T only. Therefore, if T sells the property to X, who has no notice of the trust, B cannot enforce the trust against X, though he may still have a personal right of action against T for breach of trust. We are going over to the nature of equitable interest. In the case above, T is the legal owner of the property and B is the equitable or beneficial owner. Legal and equitable interest in the said property may thus exist side by side in the same property. The legal owner is in a stronger position in that he can sell the property so as to defeat or overreach any equitable interest attaching to it, and he can recover the property from any disposes from any wrongfully dispossesses him. That is to say that his rights are in realm strongly fixed to the property itself. The equitable owner is in a weaker position in that his rights in the property can be destroyed or overreached by the sales of the said property by its legal owner, and the equitable owner's rights are enforceable only against persons who acquire legal ownership of the property with the knowledge of his equitable interest. Let's go to the purchaser without notice. A person who in good faith and for value buys property from the legal owner without notice of any equitable rights attaching to the property takes it free of such equitable interest. That is to say that the equitable interests become automatically destroyed or overreached to the favor of the purchaser. Overreaching will only take place where the purchaser gives valuable consideration for the property, that is to say that he does not receive it as a gift or for a lesser consideration. B acquires the legal ownership, not merely some beneficial rights, has no notice, actual or constructive, of any equitable interest attaching to the property. Good faith. The purchaser must take reasonable enquiries to see if any person is connected or has equitable claims upon the said property. If he fails to do so, he will be regarded as having notice of such claims, even though he did not in fact know of them. A purchaser or buyer complying with these requirements is technically called a bona fide purchaser for value without notice. We'll be moving over to the maxims of equity. Before its formalization in the 17th century, equity was extremely flexible and its main principles operated through a number of universally acknowledged maxims or were stated in a series of moral precepts. Such maxims apparently reflect the deficiency which it was introduced to correct under the common law of England. These maxims still express the spirit of equity, though they do not really cover all the technical rules now applicable. Maxims of equity are also known as the rules of equity. As aforementioned, some of the maxims include: 1. Equity will not suffer a wrong to be without a remedy. Thus, wrongs which were capable of legal redress, but for which no common law remedy was available, would usually be redressed by equity, e.g., enforcement of trusts which were not recognized or enforced at common law. 2. Equity follows the law, equitas sequitur legem, where a rule of law covered a case coming before the Chancery Court. Equity would apply the legal rule unless it would be unconscionable to do it. 3. He who seeks equity must do equity. Equity remedies will not be granted to a plaintiff who is not prepared to act equitably himself. Thus, where a plaintiff unfairly seeks to revoke a firm promise on the ground that it is not supported by consideration, he may be stopped from denying the promise. For he who comes into equity must come with clean hands. The plaintiff will not be given equitable assistance if his own conduct in the matter has in the past been unconscionable. Thus, a woman sued trustees to compel them to pay to her money which, while an infant she had already obtained from them by fraudulently representing her age, held. She could not succeed as her past conduct was unconscionable. Overton versus Bannister 1844. The maxims in 3 and 4 are similar, but 3 relates to the future or present conduct of the plaintiff and B to the conduct past conduct. 5. Delay defeats equity. Equity aids only the vigilant. Laches, that is unreasonable delay in bringing up a claim may defeat it. Nowadays, time limits for the bringing of most actions are fixed statutorily by the Limitation Act, and equity follows the law in applying the statutory limitations. Equality is equity. Thus, in dividing jointly owned property between rival claimants, equity will favor equal shares unless there is strong evidence to show that one claimant should have more than another. Equity looks to intent rather than the form. Thus, where it is clear that a document is intended as a mortgage, equity will treat it as such, even though it may describe itself as a conveyance. Equity acts in personam. Most equitable remedies operate against the defendant personally. Example, injunctions specific performance. A court order that is injunction can be enforced in 2 ways: by action in rem, that is by action against the property involved in a dispute, or by action in personam, that is by action against the defendant personally. Common law rights were usually enforced by the first method. Example, by the seizure of property or an order for damages. Equitable rights were enforced by the second method, e.g. by ordering the defendant to carry out a bargain or by forbidding him from further injuring the plaintiff. Equity looks on that as done which ought to be done. Where the parties have made a binding contract to grant a lease, equity will compel a defaulting party to proceed to execute the lease and will treat the plaintiff as though the lease had actually been granted already. Equity imputes an intention to fulfill an obligation. Thus, where a man is under a duty and does something capable of being construed as performance of that duty, equity will so consider it. Example, where A dies owing B $5 million and in his will leaves a legacy of $5 million to B, equity will not allow B to take the legacy and to sue A's executors for the debt. Equity hence presumes that a man intends to be just before he would be generous. Where there is equal equity, the law shall prevail. That is, where plaintiff and defendant have equally sound moral claims, strict legal rules will decide between them. The equities are equal, the first in time prevails. Where the equities are equal, the first in time prevails. Thus, where two persons make equally sound competing claims to property, equity will usually decide in favor of person whose claim arose first. This is a case where equity follows the law. The legal rule in which cases being qui priorest tempore potiorest jure, that is, whoever is first in time is more powerful in law, or the person who is prior in time is stronger in right. Equitable remedies. One, auxiliary jurisdiction. One of the chief ways in which equity supplemented the law was by granting auxiliary or additional remedies where the common law remedies of damages proved inadequate. Remember that the grant of equitable remedies is always discretionary. Two, some kinds of equitable remedy. A, appointment of receiver, discovery of documents, specific performance contracts and injunction. Appointment of receiver. At common law, a debtor's property could be seized to satisfy his debts, but might not his remedy might not be available in all cases. Where the debtor had only a beneficial interest under a trust. In such cases, equity might appoint a receiver to collect all profits from the trust property and pay them to the plaintiff. Discovery of documents. When in action one party has possession of documents which might clarify the case and conceals them, equity may compel him to produce such documents for the better information of the court. 5. Specific performance of the contract. This is a remedy for breach of contract and consists of a court order compelling the defendant to perform his side of contract. Specific performance is always a discretionary remedy and may be awarded in addition to or instead of damages. Specific performance will only be awarded where damages will be inadequate, e.g., in contracts for sale or lease of land or for the sale of valuable and unique chattels such as rare paintings. It will not be awarded in ordinary contracts for sale of goods where the plaintiff could easily obtain replacement articles which the money received as damages, example in the sales of ordinary cars, books, etc. B. Where the enforcement of the order would not require constant supervision by the court, example, not in building contracts or contracts of employment, Industrial Relations Act 1971 section 128. C. Where the contract is equally enforceable by both parties. Thus, an infant plaintiff cannot obtain specific performance of a contract which would not be binding upon him, since it would be impossible for the adult defendant party to claim specific performance against the defendant. In such cases, the infant can, of course, obtain damages. Where the plaintiff has himself acted equitably, he cannot obtain specific performance if his own conduct has tricky or unfair. 6. Injunction. An injunction is a court order or is either prohibitory, forbidding a person to do something, or mandatory, commanding a person to do something. Mandatory injunctions are rarely granted since they might call for supervision by the court, which may not have the resources to enforce the injunction adequately. A. Caveat injunctions issued to prevent an apprehended injury before it has occurred, but where there is a reasonable ground for fearing the injury will occur. Interim or interlocutory injunctions, usually granted pending the decision of a case, e.g., prohibiting a defendant from taking disputed party overseas until the dispute as to ownership has been finally resolved or settled in court. C. Perpetual injunctions issued when a dispute has been finally settled, e.g., where an interim injunction forbidding interference with a right of light is made perpetual when the person of light has been finally proved in court. Injunctions to restrain breach of contract. Injunctions can be awarded in addition to or instead of damages and can be available where specific performance is not. Thus, the specific performance cannot be awarded in a contract of personal services, but a prohibitory injunction might be granted to forbid breach of contract, such a contract, e.g., a firm A film star under exclusive contract to a film company could be forbidden to make films for any other company. Warner Bros. Versus Nelson, 1936. In this way, the court may indirectly achieve the same result as by ordering specific performance. That is, where the court cannot order performance because it could require constant supervision, it may achieve the same object by forbidding breach. An injunction may also be granted to prohibit X from inducing a breach of contract between A and B. 8. Injunction in other cases. Injunctions can also be used to prevent injuries in other types of cases, e.g. tort. Injunction may be granted to forbid commission of a tort, e.g. to prohibit continuance of a nuisance or to forbid a trespass. B. Trusts. An injunction can be granted to forbid a trustee from selling trust property to the detriment of beneficiaries. So we've come to the end of this. We have evaluation, and the evaluation goes as follow. 1. Define equity and explain the historical differences between equity and common laws. 2. Explain what is meant by saying the legal rights to land are rights in rem and why the equitable rights are in personam. Explain the equitable doctrine of the purchaser without notice and state in what circumstances overreaching may occur. Briefly summarize the maxims of equity and illustrate the modern working of the maxims by discussing a case in which one of the maxims was applied. Number 5. Summarize the four most widely used equitable remedies and illustrate their applications. Number 6. In what circumstances will the remedy or specific performance be awarded for a breach of contract? 7. Explain the following: clear ultimate injunction, mandatory injunction, and interim injunction. Thank you so much for your listenership and your patience in this particular study. We hope you will go through it and understand every part of these lectures. See you in the next class. Goodbye.